My Lords, I was dealing with the Fourth Motor Insurance Directive. Just before we started, Mr. Mercer handed me a one-page note, which I think is supposed to be the response to Lord Toulson's question. I've just seen it. I think insofar as there are matters in it that are relevant today, I can probably deal with it. There are certain bits in it I can't. I'm perfectly happy for Mr. Mercer to pass copies to your Lordship.
Well, if you need more time, then let's just see the note first.
Yes. As I say, I think I can probably deal with the matter so far as
Thank you very much.
this case, but there are one or two points that we can't concur with, perhaps.
Thank you very much.
Shorter is, from our point of view, we can deal with point 1 today and its relevance.
Yeah.
Points 2 and 3, I think, are rather more contentious.
Yes, I'm not. I can see that.
The relevance of
How the green card system works, I would have thought. Yes, I see. The postulate is that each motor insurers bureau agrees to guarantee the settlement of accidents occurring in its territory, even if the vehicle is based in the territory of another.
Yeah.
So
That's all under green card scheme, and obviously our central proposition is that we're not dealing with green card scheme arrangements here.
Yeah. Well, it may be that 2 and 3 don't matter, and
Yes.
indeed they don't matter on either of your cases.
Yes.
If I've started here, I apologise,
No.
but I'm grateful for those whose endeavours have produced this.
No, as I say, I think our central proposition is that although we heard a great deal about the green card scheme in introduction, what we're dealing with is a more developed scheme with a creation of a new body fulfilling a particular role under a statutory scheme. Therefore, point 1 on the note is relevant, and point 1 on the note, to be fair to Mr. Mercer, reflects the structure of the diagram he handed up yesterday as well. But I'll come back to that because I'm going to pick up those issues. So if I may, I finished up yesterday just with the recitals in relation to the Fourth Motor Insurance Directive. So we're in Authorities Bundle 1, Tab 4, at MS 341. And what I was just highlighting at the end was the fact that in the recitals where the draftsman wanted to specify which guarantee fund did what, that language was particularly used in recitals. Obviously, when we come on to Article 7, no specification is provided in relation to which guarantee fund is relevant for the purposes of Article 1.4 under Article 7. But if we then, moving away from the recitals, just move into the substance, obviously Mr. Mercer took you to various of these provisions, so I'll try and deal with them relatively quickly. First of all, in Article 1, just emphasising the objective of this directive is to lay down special provisions applicable to injured parties entitled to compensation in respect of any loss or injury resulting from accidents occurring in a member state other than the member state of residence of the injured party, which are caused by the use of vehicles insured or normally based in a member state. So these are special provisions. This reinforces the point I was just making, that what we're dealing with is not the green card, some sort of incremental change in a green card scheme. what we're dealing with is a statutory intervention to deal with a particular problem that arises vis-à-vis the position of persons suffering accidents abroad. Obviously, what it does is, through Article 3, puts in place a direct right of action and enables that, in particular through the structure for claims representatives and information centres. But it also has this particular set of special provisions.
Where do you get? Sorry,
I'm sorry.
Which were you referring to? Which recital has the word special in it?
I'm so sorry. It's not the recital. It's Article 1.
Oh, it's Article
Scope.
1,
I'm
yes.
so sorry, my lord.
No, but I was just looking at the recitals. I mean, it's quite plain that this is a supplement to the green card system, on the basis the green card system doesn't solve all problems. And
well, it's not just a supplement to the green card system. It's of course a supplement to the first, second, and third directive scheme, which I suppose one can see as statutory supplements to the green card scheme that already existed. Yeah. So the point I'm making is that what you have here is a legislator building on a legislative scheme, which in turn had built on the existence of the green card scheme. But that addition that is being brought in the fourth directive is a very particular statutory scheme, a set of special provisions. And I just emphasise that.
The aim is, according to recital 8, to supplement the arrangements,
yes,
by guaranteeing injured parties suffering loss or injury as a result of a motor vehicle accident comparable treatment irrespective of where in the community accidents occur. So it's, one would have thought it was intended to be a homogeneous scheme.
Well, certainly it's supposed to be filling in gaps, and to that extent, if it's supposed to be creating a degree of homogeneity, I can see that would be one way of looking at this. What we say, of course, is that the homogeneity that's being created, in particular in relation to these very special provisions governing a situation of overseas accidents concerning uninsured or unidentified drivers, is providing a mechanism for those particular unfortunate victims to be able simply and easily, or more simply and easily, because none of this is straightforward, obtaining compensation in their own member state from this special body that's created. And as I say, the key issue here is whether or not this scheme, on Mr. Mercer's case, specifies precisely the level of compensation that the domestic compensation body must provide by reference to some foreign guarantee fund rules. And we just say that is not what this directive's doing. That's the essence of our point in relation to it. So we recognise the homogeneity, we recognise the filling the gap. We say this is a pragmatic set of rules that are being put in place, but what it doesn't do is mandate the approach that Mr. Mercer exhorts the court to adopt. And as I say, that is consistent with the fact that these are dealing with rather special situations. As I say, I don't need to dwell on the definitions, so I don't think we have any issue in relation to those. Direct actions created at Article 3, and then Article 4's claims representatives, Article 5, information centres, and we've already seen how those, or I've mentioned how in the regulations those provisions have been transposed into domestic law primarily in the 2003 regulations. Then we get on to Article 6, which of course is the provision that is implemented by regulations in 11 and 12 in the 2003 regulations. Each member state shall establish or approve a compensation body responsible for providing compensation to injured parties in the cases referred to in Article 1. So that's just going back to the scope to which I've already referred the court. So it's creating this special body, a special domestic body, to deal with these cases in Article 1. Such injured parties may present a claim to the compensation body in their member state of residence. And then it sets out those provisions that Mr. Mercer took you through about in what circumstances a claim can be presented to a compensation body in the the member state of residence, which again reflect the provisions that we've seen implemented in Regulations 11 and 12. And you'll see under A and B, it has that caveat that again is in Regulations 11 and 12, injured parties may not present a claim to the compensation body if they've taken legal action directly against the insurance undertaking, and the compensation body shall take action within 2 months of the date when the injured party presents a claim for compensation to it, but shall terminate its action if the insurance undertaking or its claims representative subsequently makes a reasoned reply to the claim. And we saw that structure in Regulations 11 and 12 as well. Then we've got the points about the compensation body, once it's received a claim, notifying the insurance undertaking, the compensation body in the member state of the insurance undertaking's establishment or the relevant person that it's received a claim. And then there's the caveat about subsidiary and non-subsidiary rights. So all of that properly reflected in Regulations 11 and 12. And then just noting 6.2, the compensation body which has compensated the injured party in his member state of residence, so that's assuming the compensation body keeps going and deals with a claim that's been brought to it. The compensation body which has compensated the injured party in his member state of residence shall be entitled to claim reimbursement of the sum paid by way of compensation from the compensation body in the member state of the insurance undertaking's establishment which issued the policy. So just noting there, it's the reimbursement of the sum paid by way of compensation. It's not specifying what that level of compensation must be. And the domestic compensation body can make that claim for reimbursement against the foreign body. And then it says, of course, the latter body, so that's the foreign body, shall then be subrogated to the injured party in his rights against the person who caused the accident or his insurance undertaking, insofar as the compensation body in the member state of residence of the injured party has provided compensation for the loss or injury suffered. Each member state is obliged to acknowledge this subrogation as provided for by any other member state. And so here we've got the back-to-back proposition that first of all, the domestic compensation body, so in this case the UK compensation body, would pay out, we say under domestic law rules. It could then claim reimbursement from the, in this case, the Greek guarantee fund. In these circumstances, it would be entitled to reimbursement of all of those monies, so it's not left out of pocket. And then the Greek guarantee fund is subrogated to bring the claim against the injured party or other responsible insurance undertaking, but obviously only insofar as the compensation body has compensated. So it's possible, of course, that English rules might give rise to lower compensation than arise in Greece. That isn't the case here, we don't believe. But clearly the terms here are ensuring that you've got a back-to-back right of subrogation.
But it wouldn't be back-to-back, would it, as between the foreign compensation body and the party whom it was then entitled to proceed against by way of subrogation?
Well, this is what this is providing for.
Yes, quite. I mean, in this case, the Greek compensation body would be subrogated to the victim's rights against the driver. But those rights would be for the amounts that would be recoverable in Greek law. And if that was less than was recoverable in English law, the result would be that the Greek compensation body would be out of pocket.
Well, we don't accept that that is the case in circumstances where what is being required here under the regulation, under the directive, is that the subrogation is insofar as the compensation body has paid compensation.
Well, that means they can't recover. The subrogated body can't recover more than they have themselves paid to, in this case, the UK Motor
Yes.
Insurance Bureau. But the problem is they might have to put up with less.
Well,
Because if the Greek measure of loss is lower,
well,
all they're going to get by way of subrogation.
well, I'm not sure that that necessarily follows, my lord, because there are two questions here. What are the rights of the injured party to which you're subrogated in relation to the claim against the insurers here? We wouldn't, when you have a European provision which is saying that insofar as compensation has been provided for by this scheme, we don't accept that it means that you would be able to curtail the quantum of the rights of subrogation.
Wait a minute. Subrogation has nothing to do with the amount that insurers have paid. Subrogation is to the injured party's claims against the negligent driver.
It's not indemnity. They could have proceeded by way of conferred a right of indemnity, but they didn't. They used the technique of subrogation. So they've got the same rights, neither more nor less, than the victim would have had if they'd sued the driver in Greece.
Well, I think there are 2 points. One is, so far as we're aware, this isn't a difficulty that has arisen. We understand that it's relevant.
No, we're asking how the scheme works.
Yes, I quite understand.
I mean, once you accept the hypothesis, which
Yes, quite understood. That in relation to a scheme that specifies the ability to recover the sums in question that have been paid out by the UK compensation body, on this hypothesis at a higher level than would have been available under Greek law, the question then arises whether the rights to which you're subrogated in Greek law constrain those quantum issues. And what we don't accept is that the rights of subrogation, in other words, the nature of the claim that the Greek guarantee fund is able to bring, is constrained so far as the quantum is concerned. In those circumstances, we understand the process that you're identifying subrogation of rights, but where you're talking about the level of quantum...
That leads to extraordinary results. The insurer defaults and thereby throws on its insured a higher liability than it would have done if the insurer had answered the claim. I mean, the whole of the scheme surely operates on the basis, as said in Article 1.1, that the objective is to lay down special provisions applicable to injured parties entitled to compensation in respect of any loss or injury resulting from accidents occurring in a member state. So the given datum, the starting point, is the liability of the negligent driver. And to suggest that the liability of the negligent driver can be increased by an unusual concept of subrogation seems to me implausible as a matter of policy.
It also means, does it not, that this directive, by conferring these essentially procedural rights to recover on victims, has, by a sidewind, modified the domestic law of Greece relating to tort and damages, which also seems to be a somewhat surprising consequence, and it's not at all clear what the legal base for that would be as a matter of EU law.
Well, it's not that it's modifying the legal framework of Greek law. What it's saying is that it's imposing a scheme under European law that is using the mechanism of subrogation to ensure that the reimbursement sought by the compensation body flows through. And it may depend on a distinction between the subrogation of rights and the subrogation of the extent of quantum. And we say there may be a subrogation as to the rights, but
there isn't such a distinction. I mean, subrogation operates by putting the person who's subrogated in the shoes of the original claimant. And you can't be subrogated to the liability, but for greater damages than the liability involves under the law under which the claim exists. And the other constraint on subrogation is obviously that it only exists to the extent to which you have paid out monies, but we're dealing with a situation where ex hypothesi you paid out more here than the Greek negligence claim would produce.
Well, my lord, if that were to be the case, and the reason I identify that is because this scheme is specifically setting out a scheme of reimbursement which doesn't constrain as between the domestic compensation body and the foreign body from whom reimbursement is sought, any restriction there. And in those circumstances, what we are then talking about is, in these what will be unusual circumstances, the question of the scope of subrogation being read back into those terms in order to significantly constrain the meaning of the term reimbursement in these circumstances. And we say that cannot be right, and that in those circumstances it is appropriate to read the relevant subrogation powers in 6.2 as either enabling the recovery of the full amount of the compensation that has been paid, or to recognise that there may be a shortfall in relation to those matters. But that does not in and of itself mean that in respect of reimbursement that is being made and the criteria for the payment of compensation that is being identified without any limitation, that would be, I think as it was put earlier on, a degree of lumping it in relation to the process that is in place.
As between the MIB and a Greek fund, are not their respective rights and liabilities fleshed out by the agreement to which they're both parties, as I understand it? It's to say it's expressed to be an agreement between compensation bodies and guarantee funds.
Well, the interpretation of the directive and the scheme of the directive can't be dictated by the terms of the agreement. So insofar as in the agreement between the different compensation bodies, they allocate their rights and liabilities in relation to compensation, in those circumstances, that doesn't tell you what the scope of the compensation that should be afforded by the compensation body in the member state of residence, as it would be the UK. It's right that that agreement is a condition precedent of the operation of the regulatory scheme, but it's also right that the terms of that agreement are not ones that are being approved by the legislature here or indeed by the executive.
Well, that's a very English approach, but the directive is an international document. Would Luxembourg take the view that the agreement is not a relevant piece of material in construing the directive?
Yes, I don't see why that would be the case, because if one looks at Article 6.3, all it is saying is that this article shall take effect after an agreement has been concluded between the compensation bodies.
It's a bit unrealistic, that. Look at the next bit. From the date fixed by the Commission upon its having ascertained in close cooperation with the Member States that such an agreement has been concluded,
yes.
And it's an agreement relating to the functions and obligations and procedures for reimbursement. And I mean, I think my Lord's point is twofold. Firstly, I mean, are we bound by common law rules of interpretation?
Well,
but secondly, it's a bit unreal to suppose that the Commission didn't look rather closely at this agreement, and on your case, they must have made a hash of it.
Well, there are 2 points. I'm not for a moment saying that in considering European legislation, one is bound by the terms of common law terms of interpretation.
No, but I mean, we all know that in civil law countries there is a different. I think the common law is out on a limb, isn't it? My Lord will know better, probably, having looked at it at the Law Commission.
So I think I would suspect that if you were to say to Luxembourg judges that, of course, this agreement is of no relevance to the point that we're concerned about, that is, say, understanding the scheme, you might get some rather blank expressions.
You might get the same expressions from an English judge, frankly.
Then again, you might not.
It's recited. Well, it's recited,
Yeah.
it's recited in the principal legislation.
Well, the reference to the existence of the agreement is, of course, in the principal legislation. The question is, are the terms of the agreement to be read as influencing the construction of that principal legislation? We say it isn't of assistance in this regard. But more than that, it's not just us saying this. Of course, what we're doing here is talking about the scheme that has been implemented under Regulations 11 and 12. So this is not us coming along with a freestanding interpretation of Article 6. This is precisely what has been spelled out by the Secretary of State in the terms of Regulations 11 and 12. Because that is what has been done, and there's no doubt about that in terms of 11 and 12. Mr. Mercer doesn't seek to suggest that the terms of 11 and 12 produce some different results. He, in passing in his written case, says, they should be disapplied or ignored. But that isn't right. And we say it was open to the Secretary of State to reach that conclusion, that it was open to him to put in place a scheme where the primary claim in this special situation is against a domestic compensation body, and in relation to that domestic compensation body, the measure is UK compensation. And if the upshot of that were to be that in relation to rights of subrogation, which only arise when you've got an identification of the relevant insurance undertaking and you have been reimbursed by the Foreign Guarantee Fund, that it meant that the Foreign Guarantee Fund might be left with a shortfall, or might, depending on the level of compensation, be better off than if it had actually been paying out in relation to this matter itself. That is not inimical to the scheme of the directive and is not such as to undermine the terms of the regulations.
I think I've got that point, and I wanted actually to go back to something we were discussing yesterday, because thinking about it, I wasn't sure. You maintain that under the Regulation 13, as if it were the body authorised under paragraph 4 of that article, means as if it were the Motor Insurers Bureau in the UK, or at least the member body set up and authorised to provide compensation in the UK.
Yes.
In other words, as if it were itself. And it was suggested to you that that's rather odd to have a provision which says that the MIB shall compensate as if it were the MIB. And the alternative being put was that it might be read as if it were the Greek body, because it's referring to Article 1.4 of the second directive.
Yes.
And just looking at Article 1.4 of the second directive on electronic 332,
Yes.
which body is that referring to? It's saying each member body shall set up or authorise a body with a task to providing compensation for loss or damage caused by an unidentified vehicle or a vehicle for which the insurance obligations provided for in paragraph 1 has not been satisfied. Yes. Now, in the context of a Greek accident, does that not always refer to the Greek compensation body? I.e., the Greek compensation body must cover vehicles wherever they're based, which are either unidentifiable if they cause a Greek accident, in which case you won't know where they're based, or whether they're insured at all, or who the insurers are, or they must cover vehicles for which the insurance obligation provided for in paragraph 1 has not been satisfied. In other words, vehicles, whether they're Greek or French or British, which don't have proper insurance with the EU extension, which they should have under Article 3 to cover traffic anywhere in the EU.
Well, if it's the accidents in Greece,
Yes.
then that would be the Greek Guarantee Fund.
Yes.
And that is replicated in each member state. That's what Article
Yeah.
1.4 is doing.
So why I mean, if we're just looking at the words as if it were the body authorised under paragraph 4 of Article 1 of the second Motor Insurance Directive, why shouldn't those words mean as if it were the Greek, in the present case, the Greek Motor Insurers Bureau or company?
Because we say you can't just read those words in isolation, and that as we considered yesterday, and the accident had occurred in Great Britain.
Well, I agree that
It simply doesn't make any sense if it's referring to the Greek guarantee.
so
fund
it's the later words
yes,
which creates the problem.
we read it together as a package.
Yeah.
Yes, absolutely. We're not trying to sever bits of it.
Yeah.
We recognise that under Article 1.4,
Yeah.
there are 28 guarantee funds.
Yes. But each of the guarantee funds operates in the way I suggested.
Yes,
namely,
absolutely.
it covers not just vehicles which can be identified as Greek, but it covers any vehicle, and it covers a French vehicle if a French vehicle doesn't have proper insurance.
Well, yes, I mean, this is where things get slightly complicated on the basis of what Mr. Mercer's case is. Because Mr. Mercer has set out a case that a visiting victim would be able to bring a claim against the Greek Guarantee Fund in relation to both unidentified drivers and unidentified vehicles. So I think that would fit with your lordship's account. And then, as we'll come on to see in relation to Article 7...
Doesn't matter whether they're a visiting victim or not, does it? I mean, any victim of a Greek act...
Sorry, yes, absolutely. I only refer to visiting victims because that's the... But your paradigm case is obviously right. I mean, these guarantee funds are primarily set up in order to deal with the position in relation to the majority of people in any member state who will be the residents of the member state, probably the nationals.
Yeah, so it's looking at basically a Greek accident.
Yes, it's looking at Greek accident.
If we just get back to the second directive, 1.4 moment.
Yes.
The relevant member state, isn't it, is going to be the state in which the vehicle concerned is normally used. Because the obligation, the preamble, the recital, 1, 2, 3, 4, 5, 6, whereas Article 3 requires each member state to take all appropriate measures to ensure that civil liability in respect to the use of vehicles normally based in its territory is covered by insurance.
But we can understand...
Now then...
Surely that's... I mean, that's correct, but one has to look at the further recitals, doesn't one, which deal with situations where you can't identify where the vehicle is.
Right. But, well, of course, you've got a hybrid because it's 1.4 covers, of course, both the unidentified and the uninsured. So you could have one where everybody knows that the vehicle is a UK vehicle, but it's just not insured. You could have one where the vehicle isn't actually identified, but everybody knows it's a French one because the evidence is it had a French number plate, but we haven't got the full record of it.
Yes.
Or you could have one where nobody's got a clue.
No, absolutely. All of those must be possibilities. The difficulty I have in dealing with this is that the case that's made against me is that in relation to these matters, it doesn't matter. The visiting victim brings the claim against, on this hypothesis, the Greek Guarantee Fund. That's what Mr. Mercer's diagram spells out.
I wonder, therefore, whether one's not the right thing to do when you look at Article 7 of the 4th Directive and Regulation 13 is to cut through a Gordian knot which doesn't appear to have been in the mind of the drafter. Because if we look at Article 7 of the 4th Directive, manuscript MS 346,
Yes.
you've got a very brief second sentence. It simply says, the compensation shall be provided in accordance with provisions of Article 1 of the second directive.
Yes.
They don't go into any further attempt at working out how. Now, then, what the drafter of the English regulation has done is to try to give effect, has he not, to that single sentence in Reg 13.2b.
Well, certainly, as I said yesterday, in answer, I think, to one of the questions from Lord Sumption, asked why it is that Regulation 13 doesn't have the structure of Regulation 12, one can see that it may well be that the draftsman was fixing on the language of Article 7 and that reference to Article 1 of the second motor insurance.
Well, I think you have accepted that our Regulation 13 is intended to give effect to Article 7.
Yes, absolutely.
Yeah. And therefore, where you've got that reference to in accordance with the provisions of, that would strike me as reflecting what's in the second sentence. But the English drafter feels it's a bit bald to not, as we spell out any kind of connection or anything by way of explanation. And the language which follows in Regulation 13b simply could be read as, effectively, in the same way that it's bound to provide compensation to a person injured by an unidentified or uninsured driver in its own country, or any of the other cases within the second directive.
Yes.
So on this hypothesis, your lordship is suggesting that in relation to, sorry, I don't want to presume, but that rather than Mr. Mercer's account, which is that a visiting victim could sue the guarantee fund in Greece if the vehicle was a French vehicle.
Sorry, visiting victim in Greece.
In Greece, I'm
Yes.
so sorry. I'm always going to
Yeah,
stick with
right.
UK residents,
Yeah, right.
Greek
Okay.
accident.
So rather than his account that a visiting victim could sue the Greek, yes?
Suing the Greek. If this is a case where the vehicle is a French vehicle, so it's normally based in France, then in fact, contrary to Mr. Mercer's case, the claim should be against the French guarantee fund rather than the Greek guarantee fund.
Because if we go back to the second directive, we can see that it may impact on different funds in different ways, because we just ran through the permutations.
Yes.
And so the MIB could, under the second directive, find itself having to respond both in relation to a UK vehicle causing an accident in the UK and a UK vehicle causing an accident in France.
Yes.
Now, you've got those different permutations. What Article 7 of the fourth directive is doing is providing, as we know, an extension, and it's as it were building on the second directive, and simply saying, provided in accordance with, it doesn't attempt to explain quite how it is, but it's intended to be an extension of that. And my suggestion was that the English draft has just tried to give effect to it in a way which amounts to saying it's in the same way that it's bound to provide compensation to a person within who falls within Article within the second directive, which might be through a variety of different routes.
Well, undoubtedly, I can see that in circumstances where you're then saying, well, we don't approach this on the basis that the MIB has put forward, which is you always have to sue the Greek guarantee fund. You bifurcate so that where you're dealing with a non-Greek-based vehicle, you're dealing with a French vehicle, that I can see that that is more consistent with the terms of Article 1.4. It is not consistent, though, of course, with the language of Regulation 13. Your Lordship says the draftsman was struggling to capture that approach. Not only isn't that not the approach which has been put forward by MIB, but of course it doesn't take account of the fact that rather than focusing on the possible differences between unidentified vehicles and vehicles whose nationality, for want of a better word, has been identified, instead it says you will focus on the accident being in Great Britain. So in those circumstances, the language that's used there is simply not consistent.
Well, I'm not sure, because that's the paradigm case where liability can arise under the second directive. That will be the most likely one. One interpretation is the one you're advancing, and an alternative interpretation is that this is actually no more than an attempt which we can say was rather a clumsy attempt, just to incorporate give effect to Article 7.
Well, the language here, undoubtedly it's intended to implement Article 7. The question is, does Article 7 specifically require the compensation measures, now on your Lordship's hypothesis, to be a French measure in relation to a French vehicle and a Greek measure in relation to a Greek vehicle in relation to visiting victims? Is that mandated by the terms of the directive? Well, quite apart from that not being the case that's put against us, there isn't any language in the directive specifically setting that difference out. And then when it comes to the interpretation of Regulation 13, if there aren't those constraints in the directive and the draftsman looks at these matters, he or she makes a choice that the Secretary of State then promulgates of saying, well, we are going to focus the compensation on the position in relation to an accident in Great Britain, because the same problem arises in relation to your Lordship's French analysis as arises in relation to the Greek analysis. It makes no sense of the language of an accident had occurred in Great Britain, because again, in relation to a French case, or rather a claim on the basis of the calculation of loss accorded by the French Guarantee Fund, that of course wouldn't apply in relation to an accident in Great Britain in the same way.
I'm not sure it doesn't make sense, because if an accident had occurred in Great Britain, then and the accident had been a UK vehicle, not a French vehicle happened to be over here,
Yes.
then the MIB would be liable.
Yes.
And on what I'm suggesting to you, all this regulation is doing is saying, and so in the same way, so also you will be liable in the circumstances set out in this regulation. That is to say, the scenario spelled out in 13.1.
Well, I think it's clear that 13.2b goes further than that, because your
You
Lordship...
say it's clear that.
Well...
That's the submission.
Well, we say that it is clear that it goes further than that, because, as your Lordship puts it, a situation where an accident occurs in Great Britain and the Guarantee Fund in Great Britain is answerable to it, yes, is a paradigm case. But it wouldn't make any sense to simply include that paradigm case here in circumstances where the whole purpose of this section is dealing with a situation overseas. And what it's not saying...
No, sure, it's dealing with a situation where there is either no identifiable vehicle or a vehicle for which there is no insurance.
Yes, that's right.
And they're treated as parallel, and the Motor Insurers Bureau in Great Britain would have to cough up, in either case, if there was a UK accident, wherever the vehicle came from. I mean, by definition, in the case of an unidentifiable vehicle, it may come from Mars.
Seems to be that.
Yeah, yes.
Is 13.2b...
Rather hot on re-entry, but yes.
Is 13.2b concerned with the measure of loss at all? It's surely simply concerned to say that the compensation body in the UK shall have the same powers and duties to give compensation as it would have in a purely domestic case. It's not concerned with setting out what is the appropriate measure of that loss, having regards to the fact that it's a Greek liability?
Well, we say that the first part of your Lordship's proposition, that what this is doing is ensuring that the compensation body has the power to make payment to a UK resident who is injured abroad is absolutely correct. In conferring that power, what is done is to say that compensation body must act as if it were the body authorised under 1.4, i.e. guarantee fund, and the accident had occurred in Great Britain. And we say that the proper reading of that means that the power you're conferring is for the domestic compensation body to carry out its function as per the paradigm case, and as per the paradigm case, the measure of compensation will be under the domestic rules.
So, I mean, we come back to the basic point as to which the Court of Appeal made in Jacobs. Is the purpose of Regulation 13.2b exhausted by Lord Sumption's, what Lord Sumption put to you, or does it go further and regulate principles governing the assessment of damages, for example?
Yes.
And you say it goes further?
Yeah, we say it goes further, and that the language used is consistent with that the terms of the directives don't constrain that. Indeed, if there were an intention to constrain, then that would have been specified as the nature of the relevant guarantee fund. And there are reasons for that, because, of course, it means that the process that's followed is one that the domestic guarantee fund is entirely familiar with, is dealing with matters under English law in relation to quantum, and is dealing with a situation where someone is significantly disadvantaged, and in those circumstances facilitating the provision of a compensation payment to them as easily as possible in circumstances where they have been the victim of a hit-and-run accident, or they have been the victim of an accident where the insurer has failed in relation to the nature of their claim, their duties. I was going to go further through the terms of Article 7, but having had that interchange, I think it is important to stress, however, that the approach that's being put forward by my Lord Toulson is significantly different from the approach that's set out in the MIB's case as per the diagram. Because, of course, what you see in the diagram...
Yes, it's an alternative approach, but I mean, I think we've grasped the possibilities. It may ultimately turn on the second, how you read the second directive. The insurance liability is certainly on the law of the country where the car or the vehicle is normally based, i.e. you have to have a green card cover in respect of third countries. But at the moment, if you turn to the second directive, one view is the one Lord Toulson was suggesting to you. Another view is that the second directive is putting the whole onus on the law of the country of the accident to have a compensating body which compensates for all accidents. Firstly, of course, where the vehicle is unidentifiable, so it may come from any other country. But secondly, even if it's identifiable as a French vehicle, it coughs up for an uninsured French vehicle causing an accident in Greece. The Greek body would cough up. That's an alternative, which I think is the MIB's alternative.
Yeah, that's the MIB's position. But of course, if that position is to be taken, of course, that creates all sorts of difficulties, because in the case that Lord Toulson is hypothesising of the French vehicle causing the accident in Greece, and on the MIB's case, the Greek guarantee fund paying out at a Greek measure,
yes,
you then have a situation where the reimbursement claim is not by the UK body against the Greek guarantee fund. I'm sorry, I misspoke.
No.
In circumstances where it is the domestic compensation body,
yes,
i.e. the UK body, paying out at a Greek, on the basis of the Greek guarantee fund rules, even when it's a French car. Of course, in those circumstances, it's not the Greek guarantee fund that then engages in the reimbursement. It's the French guarantee fund.
But is that consistent with 7C? In case of third-party vehicles against the guarantee fund of the member state in which the accident took place.
No, I'm sorry, my lord, it's actually 7A. 7A is what I'm referring to.
7A. This is where you have an you have an uninsured car, but you know the car.
Yeah, or you know the nationality of the car.
You know the nationality of the car.
So the difficulty with the MIB's case, and the reason why it created lumpiness, and the reason why on the MIB's case there clearly wasn't a what they put as a role for the compensation body as merely a claims handler for the Greek guarantee fund, is that their case was, or is, that in circumstances where the Greek guarantee fund pays, where the UK compensation body pays out in relation to an accident caused by a French driver in Greece, the UK compensation body doesn't then have recourse against the Greek guarantee
Yes,
fund.
well, what's the problem about that? That's a specific provision in the fourth directive which short-circuits the position. If you relied on the second directive, then on the interpretation I was suggesting to you, the victim could claim against the Greek compensation motor insurance bureau in respect of any Greek accident, whether it was by an unidentified vehicle or a French vehicle, and then under the motor insurers bureau's agreements inter se, the Greek bureau would pass the liability back to the French one if it was a French vehicle. But that's one route under the second directive. If you're proceeding under the different route provided by the fourth directive, which means you don't have to go to the trouble of pursuing the Greek Motor Insurers Bureau, you simply claim against the UK compensation body, then it's understandable that there should be a short circuit, and the UK body has, if you can identify this as a French vehicle, a claim direct against the French Guarantee Fund. I don't personally see the problem. They're just different schemes. One comes later than the other.
Well, there are 2 points to make. As we've already reiterated, it doesn't tell you about the level of damages. And second of all, to characterise the compensation body merely as a claims handler in those circumstances, because it was being said it was a claims handler.
Well, you can only be a claims handler, I suppose, if you can identify someone you're handling it for. But,
exactly. And it's odd to refer to a body as a claims handler on behalf of the Greek Guarantee Fund in circumstances where it would actually be seeking reimbursement from the French Guarantee Fund.
Well, only, of course, if you can identify the vehicle as a French one. Otherwise, you claim against the Greek.
Well, I quite see that, but the characterisation of the compensation body as a claims handler for the Greek fund, which is the way in which Mr. Mercer put the case, is plainly wrong.
It's a claims handler for whichever is the primarily liable compensation body.
Yeah.
And on some cases it may be France, in some cases it may be Greece.
Well, yes, on the Lord Toulson's variation on Mr. Mercer's case, I can see that that would be the way in which Mr. Mercer may put his case. That isn't the way that it's been put by the MIB.
Well, it
Sounds as complicated as the directives.
So are we to construe 7C simply as being, which speaks of third country vehicles, as being countries who are not subject to the second directive?
Yes, that's correct.
Yes, thank you.
There's one other provision I do want to refer to that Mr. Mercer did mention in passing in relation to the fourth directive, which is the power of member states to put in place more generous provision in relation to these matters. Now, this may be an issue that really goes to relief more than it does to substance in relation to the arguments. But Mr. Mercer, of course, is saying that in circumstances where he said in his submissions that in certain circumstances where the domestic regulations weren't in general supposed to be gold plating or making things more generous for UK resident victims of overseas accidents, this wasn't material. We say that's not right. If you've got a situation where a particular individual is better off because of the domestic arrangements, and that being better off is permitted under the terms of the European law, then we say that it is not right then to constrain the terms of the domestic law in relation to that individual. But as I say, that may well be a matter for relief. It's a question that arises in relation to disapplication of domestic law where there is an alleged breach of European law in other circumstances.
And where do you get the power to...
Oh, I'm so sorry. It's Article 10, 4 on 347. I apologise. Mr. Mercer, to be fair, had mentioned this.
Yeah.
So in circumstances where, in fact, this claimant would be better off under the domestic law, then the question as to the relief that should be afforded in these circumstances in relation to her arises.
Can you just, so this is by the way, and it's a point I should probably have picked up earlier, the agreement referred to at Article 6, sub 3, page 3, MS 345, is that either the document at tab 20 or an earlier version of it? And if it's the document at tab 20, did Article 6 only take effect after that agreement had been made? Or have I misunderstood the position entirely?
This is the latest version, and so I think Article 6 took effect earlier than from the date of this. I'm not sure we have in the bundles the earlier version, but I can confirm.
Well, I would personally find it of value if we could have the version that was in force when Article 6 took effect.
It's chicken and egg, isn't it? I mean,
in fact, that's not the case. That this is the only agreement, and therefore Article 6.
Isn't it chicken and egg? Because according to Article 11, the directive enters into force on the date of its publication in the official journal, which is 20th July 2000. But under Article 6 only takes effect once the agreement's been concluded, so that presumably Article 6 is in suspended animation until, if an agreement hasn't already been concluded, until it is. Which
I don't think that's disputed. I think the question is tab 20 the first agreement which gave rise to the implementation
As
of Article
I understand
6.
it, Mr. Beard is saying that tab 20 is the first agreement.
Yes.
That may or may not be common ground.
Well, it is, my lord, and it's confirmed by a Commission decision at tab 14 of the bundle, which refers specifically to that version of the agreement.
To tab 20.
Yes.
Oh, yes.
Thank you.
Oh, it's on the application of Article 6, I see.
Right.
I'm grateful to Mr. Mercer.
That's helpful. At tab 14.
So it actually comes into effect on the 20th of January 2003,
Yes,
Article
I see.
6.
Because the agreement had been concluded in 29th April 2002, when we got all that list of signatories, including the MIBs. The Commission decision comes 8 months after the agreement, and it comes into effect the following year.
Yes.
So is Article 7 parasitic on Article 6, so that it appears to be, doesn't it? Because
I think it is,
doesn't
because
say so,
in
but
particular you have to have the operation of the claim on the conditions laid down in Article 6.2.
So Article 7 can't come into effect until the 20th of January 2003 either.
I think that is the position.
That must follow because there isn't a relevant body
Quite.
until that's happened.
So if we look at Article 10 on implementation, you've got the date for the member states publishing the relevant laws and applying them before 20th of January 2003, and under 2 they have to make reference to the directive, and then without prejudice to paragraph 1, the member state shall establish or approve the compensation body in accordance with 6.1 before 20th of January 2002 if the compensation bodies have not concluded an agreement in accordance with 6.3. The Commission shall propose measures designed to ensure the provisions of 6 and 7 take effect before 20th of January 2003, but in the event that wasn't necessary. And so you just had the decision that's at tab 14, because the agreement had been reached. So I don't think the final remark, just in relation to the first ground of appeal, I suppose just pertains to the note that was handed up this morning, because of course the predicate of the approach put forward by MIB is the account that relies on all claims being brought against the Greek Guarantee Fund, or rather all claims against the domestic compensation body being in accord with the measure of compensation that would be afforded by the Greek Guarantee Fund, notwithstanding that reimbursement could be made in relation to a French vehicle from the French Guarantee Fund. And as Lord Toulson has highlighted, if one is to rely on Article 1.4, that approach is not necessarily consistent with the terms of Article 1.4 of the second directive. In relation to the second and third points, we don't accept that those references to the green card scheme accurately describe the nature of further claims that might be available.
Sorry, why is paragraph 1 not accurate? I thought originally you said it was accurate, and it was the second, third.
No, the claim. What we're dealing with is a French uninsured vehicle.
Right.
What claims can be made by the English victim? Make a claim against the MIB as a compensation body.
Yes.
The MIB would then have a claim for reimbursement against the French Guarantee Fund.
Yes.
The law applicable to the French Guarantee.
Is that it?
Yes,
Yes, I
would
see.
be
It's that
Greek
bit.
law.
Yes, well, that's the issue in the case,
Yeah.
effectively, yeah. Or one of the issues.
One of the issues, yes. So it's not the fact of the claim being brought against the MIB, nor the fact that the MIB could seek reimbursement from the French Guarantee Fund that we take issue with in relation to that first paragraph, just to be clear. If your lordships want us to respond in relation to the points 2 and 3 on the note, we will need some time in order to do that. But I'm not sure, for the purposes of the matters that have been discussed, how germane those are.
Well, why don't you put in a brief written note within a week after this
I'm grateful.
hearing concludes today,
I'm most grateful.
but just on those limited points.
Unless I can assist the court further in relation to the first appeal ground, I was going to deal now with the issues pertaining to the second appeal ground, which is concerned with the application of Rome 2.
Just so far, what's your position on the possibility or otherwise of a reference?
Well, we say that, as I indicated yesterday, that we consider the terms of the directive leave open to the Secretary of State to make the provisions as he did in relation to both Article 6 and Article 7 which we say give rise to a scheme whereby the relevant measure of compensation given by the UK compensation body is a UK measure, we say that the directive does not mandate any alternative, and therefore we succeed. If there is doubt as to whether or not the directive does mandate, we say the directive is plainly not act clair in mandating the particular level of compensation, and therefore it would be necessary and appropriate to have a reference in relation to that issue.
It's not really mandating a particular level of compensation. Its question is whether it's act clair in pointing to a particular law as relevant, isn't it? But pointing to a particular law as relevant to determine entitlement to compensation with which these directives deal.
No, with respect, my lord, that's not correct, because what is being said by the MIB, or in the variant put forward by Lord Toulson, is that the measure of compensation that should be afforded by the UK compensation body is the measure of compensation that would be given by, in this case, the Greek Guarantee Fund. Now, that is different from applying Greek law to the question of damage and compensation. Because
the measure of compensation that would be given by the Greek Guarantee Fund is simply the same as, isn't it, the Greek tort liability?
No, this is
why not?
Well, for example, as I indicated yesterday, in the Howe case, you have an issue whereby the rules that apply to a guarantee fund may be different from the rules that apply in relation to ordinary tort liability. And in Howe, the issue was to do with limitation.
Sorry, we better look at Howe if Howe is significant. I'm not sure
I'm sorry.
Where is Howe?
This was the point I made yesterday about the difference between... it's tab 36 in volume 3.
Yeah.
Yes.
I read that, and I don't think there's anything it would particularly... Although the judge discusses
Yes.
The meaning of Regulation 13.2b, he regards himself as bound quite properly by Jacobs,
Yes.
was aware that this case was coming here,
Yes.
and perfectly sensibly rather hedges what he has to say.
Absolutely. That's the difficulty with this judgment. It doesn't spell out what, in those terms, the reason why this problem arises, because the judge is being cautious, conscious of this appeal going forward. But the underlying issue that arises in Howe is if the measure of compensation is to be in accordance with the approach adopted by the French Guarantee Fund, then you have a limitation period of 5 years. Yeah. If, on the other hand, the approach to be adopted is that compensation should be awarded by the domestic compensation body on the basis of French tort law, the limitation is 10 years. So there is a very significant practical difference. And it's for that reason I don't concur with your Lordship's suggestion that what's really going on here is putting in place a Greek law approach to the tort claim for the domestic compensation body. It is different from that.
Sorry, I think I'm not following your argument. Which compensation body are you talking about there?
Right. UK compensation body. Your Lordship said, I paraphrase, I hope accurately, isn't what's going on here really that Greek law is being applied in relation to the claim, and it's really just Greek tort law, including the rules on compensation. And I said, no, that is not what's going on here, because the provisions of Article 7 of the directive say, on this hypothesis, that the approach of the UK compensation body should be that of the Greek compensation body.
Where do they say that? they
Well-
say compensation will be provided in accordance with the provisions of Article 1 of the second directive.
Yes.
And Article 1 is providing for
Well,
compensation in respect of the loss which should have been insured.
Well, yes.
And that's the original tort loss.
yes, but my lord,
Or tort claim.
we touched yesterday on the last indent in 1.4, which says, furthermore, each member state shall apply its laws, regulations, administrative provisions to payment of compensation by this body without prejudice to any other practice which is more favourable to the victim. And what in practice that means is that when you're bringing a claim in relation to bringing a claim against the Greek guarantee fund, the rules that, or any guarantee fund, the rules that may apply can be different from the rules that apply in relation to an ordinary tort claim against the driver or the insurer.
I'm slightly concerned, I think, that we may be taking up your time going down really what is going to be rather a side alley, because questions of limitation can be rather special questions and which can arise as between different parties where there are different types of claim.
That's true.
And whether a claim for reimbursement by the French compensating body against a Greek guarantee fund would be governed by one system of law and a different system of law from the law which gave rise to the liability for which compensation was originally given are questions which may arise, but they're pretty far from what we're having to deal with on
No, that's true, but that's, I think, my lord, to do with the reimbursement mechanism. I think the point that I'm stressing here is that there is a difference between the case that's being put by the MIB, which is that the amount of MIB's liability is limited to the amount for which the Greek guarantee fund would be liable to the claimant, rather than being limited to the amount which the tortfeasor would be liable to the claimant. And we say there can be differences between those two.
Based on limitation.
And one example is limitation that actually exists in Howe. That's the reason I point to Howe, because this isn't just some hypothetical, speculative point that we're raising. It actually has come up in Howe in relation to limitation. But it can be other things as well, because you can have caps on the level of recovery that will apply to a guarantee fund that don't apply in relation to ordinary tort claims.
But the directive itself was not to come into effect until questions of contribution between different funds had been resolved by a supplemental agreement. And that supplemental agreement governs recoveries between one fund and another. I really don't see how...
I'm sorry, I'm focused on a different question. I'm not focused on the question of reimbursement. I was merely dealing with my Lord Mance's proposition that effectively the analysis in Article 7 was broadly saying that the UK compensation body should compensate in accordance with the law of the state of the accident in broad terms. And I'm simply taking issue with that because the law of the state of the accident in relation to tort may come out with a different approach and different number from the UK compensation body being liable to the extent of the foreign guarantee fund.
But I don't see anything. I mean, I thought your whole argument was that Article 7 is independent. I don't see anything in it at the moment which attaches the compensation body's liability to the liability of some other fund.
Well, it's because there are 2 points to make. I should say this is the case that is being made against us, that the measure should be that of the guarantee fund. I mean, I can understand that if the guarantee fund is liable to meet the tort claim, it comes to the same thing.
Yeah.
Well, we say that there can be differences in rules because of things like limitation and caps, and therefore, in relation to the guarantee fund's own liability.
I find it very difficult to believe that Article 7 is importing provisions about limitation.
No. Article 7 isn't importing itself provisions in relation to limitation. What Article 7 is doing is saying, on this hypothesis, contrary to our case, but on this hypothesis, what Article 7 is doing is importing for the UK compensation body the approach of the Foreign Guarantee Fund, which is what 1.4 is to do with. And the point I'm making is that it...
Yes, I mean, does it necessarily, is it really referring to 1.4? It says compensation will be provided in accordance with provisions of Article 1. Article 1 is basically the provision which says that you have to have...
It's that maximum.
It's dealing with what sort of insurance you have to have, exactly, with maximums and that sort of thing.
Well...
It's got to cover damage to property and personal injuries up to so many EQ and all this sort of stuff.
Well,
Say that it's cross-referring to Article 1.4 seems to make things complicated.
It's referring to Article 1 of the second directive, not the first directive.
No, I was referring to...
I'm sorry.
It's Article 1 of the second directive, which makes clear that the scheme is intended to cover property as well as personal injuries, and also the limits. Because the previous...
For what it's worth, that takes you then back to the first directive, because Article 1 of the second directive identifies what has to be covered by reference to...
Article 3.1, yes.
Exactly.
Yes,
the
look,
first directive.
I understand the proposition that's being put. I'm concerned that the case that is being made against us is that MIB's liability is limited to the amount for which the Greek Guarantee Fund would be liable. So that is the case that's being made, and all I'm pointing out is...
I think we're going round in circles.
That the tort measure may be different from that.
Yes.
Well, I think that you're applying the submission that was made for one purpose over literally to a whole range of other matters like limitation and maxima under domestic law, to which it really wasn't addressed.
Well, obviously I'll hear Mr. Mercer's...
I think it would also take the case being put by the court, because we may not see it the same way as either of them.
I quite understand the point that the court's putting, but my understanding of Mr. Mercer's case was that he was concerned to limit it to the rules that apply to the Guarantee Fund, because it may well be that MIB considers that there are a range of rules that apply to foreign guarantee funds that they consider they would benefit from. So I'm not sure, my lord, that it is taking a submission for one purpose and using it for another. I think
we may have to use our own initiative in working out what this means.
I mean, I think it's pretty plausible if Greek law had a 1-year time limit for claims against the Guarantee Fund, that we would read that into Article 7 when a claim came to be made against the UK compensation body.
Well, that may be so, my lord. I hear your lordship's point in relation to that, but as I say, my understanding was the MIB would like to be able to rely on that.
Yeah.
And if that is the case, that is of concern, and this is a significant difference.
I mean, I see the point, because the back-to-back problem.
Yes.
No, I do see it.
Yes. So we saw it as not merely a limited submission, but rather the predicate to their case. Hence the concern. I'm sorry to cavil at what might seem a marginal point, but because in practice it may result in significant arguments about caps, limitation, and so on, it is right to highlight it to the court.
It wouldn't, a 1-year limitation period on the part of the Greek Guarantee Fund as against the victim would not be read into the agreement between the various compensation bodies. There's nothing in there which says you read in that sort of limitation period. Presumably that agreement has its own 6-year period or whatever under English law.
The most it would do is affect the right of segregation.
I'm not sure.
Anyway, shall we go on to...
Yes.
You were going to go to Rome 2?
Yes, I was going to refer to Rome 2. Now, obviously, the Rome 2 argument only arises if you're with us in relation to the first ground. Your lordships plainly have the core issues here. As I've already adverted to, the Rome 2 argument is slightly different from the primary argument on appeal that's put forward by Mr. Mercer, in the sense that it is arguing for a choice of law here, rather than reference to a guarantee fund measure. We also note that Rome 2 is prayed in aid as some sort of simple way of identifying the relevant law of the accident as being the basis on which compensation should be assessed. That is plainly a huge simplification as to the rules under Rome 2.
I'm so sorry, this is entirely my fault. I don't know how you turn this thing off. Oh, it seems to have turned itself off.
There is a secret button, top left.
Apologies. Would you like to start the sentence again?
No.
The second point in relation to Rome 2 is the introductory point is that it's put forward as suggesting a simplistic way of ensuring that the law of the place of the accident is the relevant applicable law, or that is part of the sentiment of the submissions. And in fact, of course, Rome 2 is far more complex than that. But if we could just turn up Rome 2 itself, that we have in the first authorities bundle, tab 7, I'm sorry. The first point to raise is in relation to Article 1, which is concerned with the scope of Rome 2. And one sees this regulation shall apply in situations involving a conflict of laws to non-contractual obligations in civil and commercial matters. It shall not apply in particular to revenue, customs or administrative matters, or to the liability of the state for acts and omissions in the exercise of state authority, acta ure imperii. You will have seen from our written submissions that we make 2 points in relation to Article 1. The first is that we say that no conflict of laws issue is raised by the creation of the compensation body scheme. The compensation body is not any sort of ordinary insurer, and the claims against it aren't tort claims against a tortfeasor. We say that the regulations create statutory obligations on a domestic body to make payment applying particular domestic rules and using domestic assessment principles by treating the relevant accident as having occurred in the UK, where the claimant has her habitual residence at the time of the accident, and therefore they're not actually trespassing on any territory covered by Rome 2. The mere fact that liability under the regulations is triggered by an accident occurring abroad doesn't mean that a conflict of laws problem arises. The fact that the trigger for a statutory scheme providing for compensation for a UK resident visiting victim in limited circumstances doesn't mean that rules of assessment of damage under foreign law must then apply to a domestic body in the assessment of the compensation to be paid. And of course, this issue must be considered aside from simply the terms of the directive, because what this contention is coming forward with is a suggestion that where a statutory scheme is put in place, which is affording compensation to a visiting victim, that Rome 2 must mean that that approach that is adopted under statute is on the basis of the foreign law as specified under Rome 2, and in particular the emphasis has been placed by the appellants on the law of the place of the accident. And we say that cannot be right, and indeed if Parliament were to suggest that actually it wanted to afford visiting victims for whatever reason further compensation predicated on the fact of their having suffered a hit-and-run accident, for example, in a foreign state, Parliament would be entitled to do so and would not see itself bound by the terms of foreign law in relation to these matters. Similarly, we see no risk of any conflicting or unenforceable judgments, which of course is part of the overall purpose of the set of applicable law rules that are developed in Rome II. And we say that in the circumstances, contrary to the appellant's suggestion, the approach of saying in relation to this particular statutory scheme that Rome II does not apply because it doesn't raise conflict of laws issues is far from incompatible with issues of legal certainty which Rome II is seeking to protect.
It may be the first question under a different guise, because if the scheme here is to pick up and provide convenient procedures for giving compensation in respect of tort claims, then it refers to tort claim, and the tort claim will be governed now by Rome II. But if, as you are suggesting, it's not linked to that, and it's simply a scheme in the air for giving any sort of payment or compensatory payment which the domestic jurisdiction may, relevant domestic jurisdiction may think appropriate, then it's not tied to any tort liability, it's independent. So it's perhaps the same first question in another guise.
Well, it's only tied in the sense that the existence of liability, tort liability under a foreign law must be a predicate condition of the scheme.
Right, so that bit would be governed by Rome too.
Yes, that would have to be governed.
So there's a Court of Appeals distinction between the liability and
absolutely. So that would have to be, but that doesn't mean that thereafter the approach that is adopted by the statute in relation to the consequences of that trigger having been met mean that all questions of compensation must then be dealt with under the terms of the foreign law. Now, I quite accept your Lordship's proposition that if you'd already found that actually what the scheme was required to do was simply recompense for, arrange a procedure for the recompensing of a tort claim, then in those circumstances we never get to this question in any event.
Yes.
So this Rome II issue only arises if we are right in our response to the first appeal, and if we are right in relation to our response to the first appeal, that it was open to Parliament to set up this scheme which put in place measures of compensation under English rules. Rome II does not quash that, because that is a separate statutory scheme that has been established and doesn't give rise to a conflict of law problem. And as we put it in the alternative, even if it might be said that some sort of conflict of law issue arose, it certainly isn't in relation to civil and commercial matters. And we've cited in our written submissions and have referred to various cases, in particular Rufa and Le Choritu, where consideration was given to questions of civil and commercial matters. And Mr. Mercer referred to the case of Henkel. None of those cases assist Mr. Mercer. If I may, I'll just very briefly go to Rufa and Henkel in respect to these matters. So Rufa is at Authorities Bundle 5, tab 63. And this case concerned a collision between vessels in Bight of Wattam, where one of the vessels sank. Now, the Bight of Wattam's a public waterway between the Netherlands and Germany, in respect to which both countries claim certain sovereign rights, and there's a treaty governing the responsibility of the two countries in relation to administration of the waterways. And in particular, that treaty provides that the Netherlands should be responsible for the administration of the waterways in the Bight of Wattum, and that involves, inter alia, the removal of wrecks. And in this case, what was of concern was the Netherlands taking action to remove the wreck and then claiming the costs of that removal from the owner of the vessel. And one can pick it up. That introduction is just set out effectively at page 1702 in the opening paragraphs of the Advocate General's opinion. But if one goes to the judgment of the court, which begins at 1711, that actually also sets out the background, and turn on to the first question over the page 1712, paragraph 6. In its first question, the Hoograad asked the court to state, first of all, whether the concept of civil and commercial matters in Article 1 of the Convention must be construed as including a claim for redress, such as that brought in the instant case by the Netherlands state. And then there's reference to various cases concerning the term civil and commercial matters in 7.
It's the wrong way round, isn't it, this case? I mean, this is a case where the state exercised public powers and sought to recover from a private person. Are you suggesting, I mean, we're dealing with a situation where a private person is claiming against the state. It's a rather radical suggestion that can't give rise to civil rights. One would have thought that people have all sorts of civil rights against the state.
Yeah, undoubtedly, the people do have all sorts of civil rights against the state. What we are saying is that in this case, what we're dealing with is a statutory scheme which is giving monies, and we say that this is a public law governed scheme, effectively.
Well, I mean, don't I have a civil right to my pension, for example? Would that be outside the scope of the, assuming I were to retire and claim it?
Well, I venture to imagine that you do have some contractual rights in relation to...
Yes, but I mean, it's a state, well, it's actually a state scheme. It's a statutory scheme for judges. It seems to me rather a radical proposition that just because it's a statutory scheme, therefore it isn't a civil right.
No, I'm not going so far as to say just because it's a statutory scheme, it cannot give rise to civil and commercial matters. But when you are concerned with a scheme such as a compensation scheme that has been developed by the scheme of the directives then implemented, which is to afford compensation in very particular circumstances to those who have been unable or are not in a position to identify vehicles, or the drivers of the vehicle or the insurer, that the public scheme that is being put in place is not one which is giving rise to a civil or commercial matter. It is not an ex gratia payment, of course, because there are certain thresholds that are necessarily being crossed, but it is undoubtedly the discharge of a public function that has been put in place by the statutory scheme in those circumstances.
The reason I referred yesterday to State of Norway's application is that I think from memory, and one's memory can be very faulty in these circumstances, that it explains that the origin of the phrase civil and commercial matter is the distinction which is made in a number of civil law jurisdictions between private and public law. I think this is a point which tends to support the submission that you are making.
Yes.
And it's intended to exclude anything which depends upon the administrative law in particular of the relevant state.
Yes, that is our understanding of the position, and it is also the basis on which we distinguish between, for instance, pension rights that my Lord was referring to, and rights
There
such
may be a
as
difference between pension rights which are earned by service, which are of the nature of contractual rights, whether or not, as a matter of English law, they would technically be classified that way, and, for example, a state pension, which depends purely on public law.
Yes, or indeed non-contributory schemes. Yes. I can see that there may be all sorts of lines to be drawn
Non-contributory
in.
schemes are earned by service, but state pensions are not.
Yes.
Certainly not in the same sense.
No, and we are not for a moment trying to traverse all of the possible lines that need to be drawn in relation to civil and commercial matters. We identify simply here that where a public authority in the situation that the compensation body is, so created by the statutory scheme in order to give money in circumstances where we recognise that the compensation body would be governed by public law, that in those circumstances the matter is not one of civil and commercial matters under the terms of Article 1 of Rome 2. And
this is a rather important point if we were to decide or have to decide it. I think you better produce some more authority quite quickly if you can, which actually bears on the sort of point that my Lord was referring to, because and this is a point which doesn't just affect the Rome 2 regulation, it certainly affects the Brussels regime.
Absolutely, indeed.
And for my part, I'm not sure that I do accept the distinction between administrative law matters and other civil law matters as the relevant distinction in this context. We haven't got State of Norway, have we, at the moment?
No, we haven't.
No. And I can't believe that there isn't European court authority which helps us a bit more.
This is obviously answering a point on appeal, and I'm dealing simply with the cases that have been put forward. But in relation to...
It's your case.
It's your case, I agree.
But in relation to the issues concerned, in relation to the cases that have been put forward in respect of the categorisation of civil and commercial matters, I've referred your lordship to the position in Rufer. I quite accept that in those circumstances it was a public authority pursuing costs, but the point that was being made there was that because it was seeking reimbursement of costs in relation to matters it is undertaken by reason of its public functions,
yes,
that in those circumstances it shouldn't be treated as a...
Yeah, I can see that, but I mean, it's a completely different case from the present. And I mean, your case amounts to this, that if you'd been claiming against the insurers, you could use all these European directives or regulations, but if you're claiming in the alternative against the compensation body, they don't apply, and that strikes me as slightly odd.
It's fair to say that State of Norway's application was similar to this in the sense that it concerned a tax liability, liability to a state duty in Norway.
Yes.
If this area is going to be explored in written submissions, I would also be interested to know a little bit about how the status of the MIB stands in relation to this argument, because there are all sorts of compensatory funds set up by professional bodies to cover professional liabilities, which they're required to do by statute, but they wouldn't ordinarily be seen as a public body, and in fact they're paid for by the members of the profession. Now, MIB, of course, is a consortium of insurers, and it all comes out of the premiums that motorists have to pay.
Yes.
So I'm simply ignorant on this question to what extent that public bodies include a compensation body of that kind.
Well, let me come back to that, because that in part is the reason why there was a reference to the Farrell and Whitty case that was picked up. Because in Farrell and Whitty, what occurred was that the Irish High Court identified the Irish MIB as being an emanation of the state. Now, going back to a point that my Lord Sumption made yesterday, we're not saying that in order for matters to be civil and commercial matters, the body concerned has to be an emanation of the state. But if the body concerned is an emanation of the state, then in those circumstances, when it's exercising its powers as such, we say that plainly it falls outside the scope of civil and commercial matters, and that is the closest indication that we have, but we recognise that's a matter that is on a reference to
A
that.
private body can exercise public and indeed statutory functions.
Yes,
a lot of examples of that.
Yeah.
Yes, absolutely, and
The most notable possibly being the takeover panel,
yes.
which had no public law status as an institution until it was given it by EU directives, but was nevertheless treated in DataFin as exercising public functions.
Yes, I'm certainly not suggesting far from suggesting that in order to fall outside the scope of civil and commercial matters, one needs to be dealing with an emanation of the state. Plainly, private bodies can be engaged in activities that are in discharge of public functions, the takeover panel being the early clear example from the case law.
It may depend what one's looking at. I mean, if you're at the moment looking at the claim against the MIB, but if the claim against the MIB requires one to consider what is the governing law or the law governing the original tort, that is a discrete issue, which is really an issue between the tortfeasor and the victim, and that could well be subject to Rome 2, even if the claim against the MIB itself is not subject to Rome 2.
Well, what I think, in accepting the broad proposition that it depends what it is that is being dealt with by the public body, yes, I think that's undoubtedly right. We say that on the basis that we're right about the first ground of appeal issue.
Yes, you say you're not looking at that.
That's why it's dependent on your being right on that.
Yes, we recognise that's the case, and we recognise that therefore these arguments fall to be dealt with in the context of a particular compensation scheme having been instituted that affords for the provision of compensation at a domestic measure, and that in those circumstances to treat that provision as anything other than the discharge of public functions is not correct. And I think I've mentioned RUFA. In our submissions, we've also referred to the Le Choritou case, which is in the bundle at tab 57, same bundle 5 at tab 57. And here, the court was concerned with a compensation scheme albeit a very different sort of compensation scheme from the one that we're dealing with today. But one can see it described at page 1629. I just invite the court to read through through to paragraph 12 there.
Again, it's rather a long way away from this case.
Yes, I entirely accept the facts are, but we're dealing with a compensation scheme, and what one sees then is when one comes to the consideration of the referred questions at paragraph 27 onwards. At paragraph 29, the reiteration that the concept of civil and commercial matters must be regarded as an independent concept. And then at 30, according to the court, so this is at page 1635, that interpretation results in the exclusion of certain legal actions and judicial decisions from the scope of the Brussels Convention by reason either of the legal relationships between the parties to the action or the subject matter. And then there's reference to the cases of Rufer and Henkel and one or two other cases which we haven't included in the bundle, but I think for these purposes don't add.
But there wasn't a compensation scheme, was it? It was simply a straightforward claim for compensation.
Yes, I'm sorry, it wasn't a statutory scheme, so it's a fortiori our position to some extent, but it was the nature of what was at issue here.
Well, I think it sounds more like a claim which would be subject to the laws of war rather than any ordinary civil
Well, I entirely accept
jurisdiction.
it is not on all fours with the situation that we're dealing with. But
paragraph 33, it appears to be envisaged that what takes it outside the category of civil and commercial matters is that the action is brought by the state to collect on a public liability.
yes,
Well, that was Rufa, though.
but that's referring to Rufa, the paragraphs. Which
Yes, but that is what is said
Yes.
here.
Yeah, and to that extent, what we are saying in relation to this is that the state is discharging the functions that are set out in relation to the directive, and will be governed by public law in relation to them. The fact
Paragraph
that
36 is...
yes.
Right, well, I'm afraid your time is
as well, because obviously
expired.
the final issue in relation to this, though, is just picking up in relation to Henkel, which was the case that was referred to by Mr. Mercer in relation to that. Obviously, that's just for your notes in tab 75 of the supplemental bundle. And of course, there, what was at issue was a person operating particular contractual terms that was said to be unfair, and a body coming along and effectively acting as a representative claimant in that case.
Where is Henkel?
Henkel is 75,
Yeah.
tab 75 in bundle 6. And this is relied on by the appellants as pointing the other way and suggesting that what we're dealing with here is more akin to private rights, because here what was being said was that the claim being brought by a consumer protection organisation.
Yes, it's the German equivalent of which?
Yes, it's very much of that
It's
sort.
effectively a sort of statutory assignment.
Yes.
And because the underlying cause of action is a private law rights, it's a civil and commercial matter.
Exactly. So we take no issue with that, but we don't think that this suggests in any way that the sort of scheme that we're dealing with here should be treated as a civil or commercial matter. So, as I say, we included Farrell and Whitty as well, simply on the basis that the High Court of Ireland has indicated that it treated MIB as an emanation of the state, but it is a matter on reference. We say that all the indicators are that in relation to this scheme, it is not a civil or commercial issue, the provision of compensation under the scheme as we describe it, and contrary to the first ground of appeal. We do have a further argument in relation to the operation of Rome II, which we have set out in our written pleadings, and I simply mention it by reference to them, which is that under Article 4.2 of Rome II, which is the exception to the general rule about the applicable law being that of the place of the damage, it says where the person claimed to be liable and the person sustained the damage both have their habitual residence in the same country at the time when the damage occurs, the law of that country shall apply. And there is a dispute between the parties as to whether or not the person claimed to be liable in the context of this statutory compensation scheme has to be treated as the tortfeasor or as the compensation body. And we say that it should be the compensation body on the basis that we have not succeeded in relation to our first ground. And that being so, the applicable law here would in fact be English.
This isn't a tort claim against the compensation body. That's the one thing that's clear, isn't it?
Well,
I mean, it's not a claim in tort.
Well, if it's not a claim in tort, and
Get back to the first point, that one has to identify the issue to which
yes, absolutely.
Rome II might apply.
Well, I mean, the question is, our first two issues in relation to Rome II are, is it a conflicts of law issue? Does it involve a non-contractual obligation in civil and commercial matters? We say if we're wrong on both of those, then there's a further issue that actually arises when you come to apply Rome 2 here, which is whether or not the person claimed to be liable is the compensation body, because that's the party to the claim, or the claim for compensation body, claim for compensation, or the tortfeasor. Plainly, if it were the tortfeasor, 4.2 wouldn't apply. We say...
Well, I think we've got the point.
And I just refer, the only relevant authority we've identified in relation to this is DICE, Authorities Bundle 2 at tab 24. And I would also just refer you to recital 18 of Rome 2, which is talking about this exception under Article 4.2, and it says the exception to the general principle is creating a special connection where the parties have their habitual residence in the same country. So those are the two relevant indicators that we have, that in fact, if we were to go down the route of Rome 2, we would be looking at applicable law being English law in any event. But as I say, those issues only arise if, first of all, we're wrong in relation to the first appeal ground, and then furthermore, we're wrong in relation to our other arguments pertaining to Rome 2 in any event. Unless I can assist the court further, the court has well in mind the seriousness of the issue from the personal perspective of the respondent who did suffer terrible injuries and has sought substantial claims applying English law principles. We recognise that there's no evidence as the Greek law of likely value, but there is significant concern from her perspective that in practice she would be able to recover far less in this case. We recognise that those matters are not the central issues in relation to the legal points, and we have set out our position in relation to the two issues on this appeal. Unless I can assist the court further, those are our submissions.
Thank you very much indeed, Mr. Beard. Ms. Crowther? Mr. Mercer?
Mr. Beard's, I'm from Mr. Beard's interpretation of Article 7 of the Fourth Directive would give no meaning to the definition of injured party from the First Directive imported into Article 1.1 of the Fourth Directive. The injured party is someone entitled to compensation. That is already entitled to compensation against someone else. So you have to look at the nature of the primary liability which underlies the Fourth Directive. There are different entitlements are relevant in different articles. In order to have a direct right to sue the insurer, in order to receive under Article 3 the direct right to sue the insurer, you would need to have a right against the tortfeasor. In order to bring your claim under Article 6, you'd need to have a right against the insurer. In order to bring your claim under Article 7, we say that the relevant right is the right against the guarantee fund. That is the guarantee fund at the place of the accident. So, but it's that entitlement to compensation that it's the starting point of the Fourth Directive. You're not within it unless you have that. It was put to Mr. Beard about the intelligent scheme. He rejected this analysis, contending that the Member States had freedom under the directives to apply the law of the victim's residence. There's no reason given for this to qualify as an intelligent scheme when set against the Green Card and Directive scheme. Nothing in the directives or the TRAVO supports that award of the damages of claimants of the claimant or the victim's residence, an idea which I think was, if I recall correctly, was put forward as a possible line in the preparation of Rome 2, but rejected. The relevance of the broad picture in my diagram, when I go back to my diagram, is that you've got overlapping, interacting schemes of the Green Card, modified by the First Directive, and the Second Directive, the Guarantee Fund. But each of these schemes, for the Green Card as modified, for travelling vehicles, both insured and uninsured, the modified Green Card scheme centralises the law applicable as being Greek law. The Second Directive is entirely consistent with that. It also would apply Greek law for the Greek Guarantee Fund. And the Fourth Directive is not something which is just an add-on, something special on the side, a separate arrangement, as Mr. Beard said, but something which is an inherent part of the scheme. It applies to all accidents insured and uninsured, where the victim is resident abroad. On the risk of English law giving you less damages, my friend submitted that you could bring proceedings in the United Kingdom and then maybe bring a top-up claim elsewhere. There's no warrant for this approach anywhere in the scheme or the words. It would mean that the fourth directive would give partial compensation. And that in turn would recreate for claimants the very dilemma which the fourth directive is designed to avoid. It's designed to be able to permit the claimants to sue in their home state, sue the compensation body, not to have to think, well, if I sue here, if I get that, and if I sue there, I get that. My friend made the point that his interpretation would make it easy for a victim because both the claimant and MIB would be dealing under English law. But the answer to that is that in an insured case, the claims representative of the insurer does deal, in the UK, for example, an accident in Greece, if it's an insured case, then the claims representative of the Greek insurer in the UK, UK personnel, will be liaising with the Greek insurer to take instructions. And one sees, if I can just draw your Lordship's attentions to paragraph 7.3 of the Fourth Directive Agreement, which I perhaps went over quite quickly. So the Fourth Directive Agreement is in Bundle 2.
That's the provision where the guarantee fund has to provide the necessary advice and so on to the compensating body.
You're ahead of me, my lord. Indeed. And advice in particular on the content of the applicable law. It's 660 yes. In tab 20. So 7.3 on 660. Guarantee fund of the member state in which the accident took place, even though it's not responsible for reimbursement, described in section 3 below, shall provide, upon request, the compensation by which a claim for compensation is made, all necessary advice, assistance, and information, in particular on the content of the applicable law, and all documents it has available relating to the accident which this body wishes to obtain.
Could I just clarify one point with you, please? And that is, in paragraph 1 of your response to Lord Toulson's question, you say that the law applicable in those circumstances by the French Guarantee Fund would be Greek law. Is that on the basis that we look at the Fourth Directive Agreement and what's said there, and that the Fourth Directive plus that agreement supersedes the final paragraph of paragraph 1.4 of the second directive, which seemed to suggest the guarantee body applied its own laws?
Yes, it's due to I think it was Lord Mance who referred to it as a shortcut, because in a sense, what you've got on my diagram, the normal route would be that the compensation body would go to the guarantee fund of the, compensation body, no. If it's a visiting vehicle, so it's a French vehicle in Greece, yes, then it would be handled under the green card scheme between the paying bureau and the handling bureau. Yes. That would be the normal route. And then frequently there would be provision under internal member state where the vehicle is normally kept for some sort of reimbursement between guarantee fund and paying bureau. And so, but the nature of the guarantee under paying bureau, handling bureau, is the handling bureau guarantees that it will handle it under its own law, and the paying bureau guarantees that it will reimburse under the law of the place of the accident. And so it is a shortcut for convenience to avoid the UK compensation body going to the handling bureau in Greece and then going on to the paying bureau in France. It's a shortcut, but it doesn't change the position as regards that centralising, as I've called it, of the applicable law.
Your submission yesterday, I think I'm right in saying, was that the final paragraph of Second Directive 1.4 had to be read in the context of the matters to which that directive applied. Namely, it was concerned with domestic accidents covered under the green card, so that it's totally irrelevant, you submitted, to an accident occurring elsewhere, something which didn't come into the scheme until the Fourth Directive.
Indeed, my Lord.
Have I correctly understood your
Indeed,
submission?
Indeed, my Lord, you have.
It's really another way of what I was saying, that the Fourth Directive and the agreement had superseded that regime as far as the Fourth Directive is concerned.
It's not superseded, I suppose. They're parallel regimes.
It's a parallel regime.
I mean, you can still go to the Greek Motor Insurers Bureau if you have an accident in Greece, but it's much more convenient to go to your local one.
Indeed.
I see. Thank you.
Maybe your second sentence of the first paragraph is a bit elliptical, because what we're really focusing on is the law applicable to the liability in respect of which reimbursement is sought. Is that not right? I'm not sure.
Yeah, indeed, my lord, yes.
I'm not actually sure what law would apply between under Article 7 between the compensation body and the guarantee fund. Maybe it would be the same law, but
The law governing the accident.
it probably is the law. But anyway, what matters is by reference to what law do they measure the reimbursement?
Indeed, my lord, yes. And just on Regulation 13 itself, I probably skipped over it a little quickly, but and I think Lord Sumption had obviously been reading it overnight, or it would come up independently with the same reasoning as Lord Justice Moore-Bick, because it was the meaning of those words, as if the accident was in Great Britain and as if the guarantee fund were authorised. I would have noted down is that the compensation body would have the same powers and duties to give compensation as in domestic cases. And it's in Jacobs at paragraphs 33 to 34. It's particularly the end of 33, the last sentence of 33. Essentially what Lord Justice Moore-Bick is saying, he finds out what these words are doing, and then he says, well, do they have a supplemental purpose?
Yes, you agree with the first point, but you deny the second.
Indeed, absolutely, my lord. And really,
But who do you say is the body authorised under paragraph 4 of Article 1 of the second directive? Do you say that that is the UK compensation body or the Greek compensation body?
we say it's the UK compensation body.
Yes.
The UK Guarantee Fund, in fact, because it's to impose a liability which would only bear qua Guarantee Fund.
And the reason why it's there is because we know that we're actually dealing with a Greek accident, say, because we're dealing with an accident outside the UK, and therefore we actually know that the body authorised under paragraph 4 of the Article 1 of the second directive in this context is in fact the Greek one.
Indeed.
But in order to make the UK one pay in the first instance, you have to pretend that this is an accident in the UK and and that the MIB is the relevant compensation
Absolutely, my
fund.
lord.
But it's dealing with that, and you say not dealing with anything more.
Well, indeed. And when one comes on to Mar leasing interpretation, we say that's straightforward in this case. There's no breaking the language of Regulation 13(2)b, because in fact, to the contrary, what my learned friend himself is trying to do is to add a supplemental purpose. And that was successful in Jacobs. Obviously, one respects the fact he's doing that. But in Mar leasing terms, we're not reading anything down. We're just giving it the meaning which is consistent with the scheme.
Well, Mar leasing normally applies when the alternative would be a conflict with the mandatory provisions of the directive.
Yes.
I think the argument against you is that this is something which the directive doesn't mandatorily specify, so that Mar leasing just has no application.
But Lord, and on that, obviously, that's the interpretation. It really depends on the meaning of the in accordance with words in Article 7 of the directive.
Yes, I mean, your case turns on those words and the various recitals 25, 29, 31, which support, as you say, your view.
Indeed. When put within the scheme and not just focusing on the bottom right-hand corner of my diagram. That's, but I don't want to repeat that, because the bottom right-hand corner is where my learned friend's just looking at this as a special separate arrangement. And Article 4 is a special separate arrangement you can look at in isolation. That's a critical part of his case.
You've got an explanation of Regulation 13(2)b, but I mean, if it's necessary to look at it, Regulation 12(4)b remains a puzzle, doesn't it?
It is, my lord. I mean, it may be difficult, we recognise, to use a Mar leasing interpretation on an express choice of law in 12.4b. But of course, under Article 6, Regulation 12, that is an insured case. And the compensation to which you're entitled refers to the claim against the insurer. And so to the extent that there can't be a mile leasing interpretation, we would submit that Rome 2 clearly, whatever my learned friend's arguments on Article 7 and Regulation 13, clearly bites.
You have to use Rome 2 to
Absolutely.
to negate.
And
Absolutely.
so you say that English law for this purpose includes English rules of private international law.
Well, either that or it can't stand with Rome 2.
Or that what's been done, effectively, of course, one understands the thinking. It's a Harding and Whelan's-like thinking. Of course, the substance and procedure distinction, as my friend pointed out.
That's spent once Rome 2 comes in.
Yes, indeed, my lord. That's the point. And so we've got the case in the bundles Bollman from the Court of Justice of the European Union. I think it's either paragraph 2 or 4. It's a short case.
You would say, you'd say this is actually, it's not just Harding and Whelan's that's spent. In fact, you would say that this was erroneous when it was enacted.
Well, we would. I'm sorry, my lord. We would. That's on our primary case, yes.
Yes.
But we would say if there's any
But it's
doubt...
contrary to the scheme
Yes.
of the original green card scheme, the agreement between the insurers, which all make it quite clear that you're looking at the law of the place of the accident, you say.
And so, we simply come on that certainly from Rome 2, it's put beyond doubt, because Rome 2, we're not allowed as member states to supplement or add to, I think those are the words, or supplement or alter, I think maybe supplement or add to. So we cite Bollman in our written case. Supplement or add to an EU regulation which is directly applicable. Then on the choice of law issues, I was just coming back thinking overnight about the exchange I had with Lord Sumption, my Lord Sumption yesterday. Of course, when you have a statutory scheme like the one we have here, the initial legal analysis is as a matter of construction. So you do look at the regulations, does it apply? If it applies, what's covered? And that is pure construction. So we agree with Lord Sumption there. Depending on the terms on which the statutory scheme provides coverage, that may be necessary to look at a choice of law at the second stage. And our primary case, of course, is that the MRB is simply liable for the primary liability of the Greek Guarantee Fund. That liability is defined in the direct, we say, is referred to in the directive. So there's no choice of law issue. You only get to a possible choice of law issue on our alternative case, for which the premise is that the MIB liability, effectively, is the uninsured driver's liability. That's the beginning of Lord Justice Moore-Bick's analysis. And in that context, there is a conflict of laws analysis, we say, to be had. What law governs that liability of the underlying tortfeasor? This is what Lord Justice Moore-Bick started to do. Common ground that Rome 2 would apply against the driver would result in Greek law. And then one just must go on and apply the Rome 2 law to damages. And so on that analysis, there's no question of anything not being civil and commercial, because on my premise, which is that MIB's liability is an uninsured driver's liability, then that's clearly civil and commercial. And on this analysis, in certain cases, the relevant law might be somewhere other than the place of the accident, because that's the way Rome 2 can lead. But of course, that in a way is a good reason why, as a matter of the scheme, our primary case is correct. So we would say that on either analysis, the issue of civil and commercial doesn't arise, because the existence of the direct right of action is simply a matter of construction. We looked at the state of Norway, but perhaps not with as much care as we should in terms of the comparative law analysis. I mean, the argument was addressed partly on the basis of the Brussels Convention, meaning of civil and commercial, but Lord Gough was reluctant to use that because he felt that civil and commercial in the UK context might have a separate meaning, and so didn't assist him in the determination of the case. I mean, but as your Lordship observed in argument with Mr. Beard, it was a tax case. There were tax proceedings in Norway, and it was seeking evidence in the UK in support of proceedings in Norway. And one might think that the recovery of a tax debt is, first of all, very obviously the exercise of a state power, and possibly, secondly, is the most public law sort of action that one would imagine.
I think the fullest analysis of the phrase comes in the judgment of Lord Justice Carr in the Court of Appeal. But I mean, where this is quite possibly a marginal point.
So I think just dealing with Moreno and Friend's points on, just very briefly on those, on the cases you mentioned. I mean, the trouble is that they are essentially the wrong way round. It's a body, as Lord Mance really said, I think, that a body, whether public or private, exercises a power such as clearing away wrecks in the Bight of Bochum, and then seeks to charge for it. So you've got very obviously the exercise of a power and a special power granted by the state for that particular purpose. It's not dealing with the imposition of a responsibility or a liability. It's in no way determinative that this is a statutory scheme giving monies, and that's one of the cases my own friend cites. He didn't refer to an argument, but Farnenbrook at 5/50, paragraph 56. So it's bundle 5, tab 50, paragraph 56. Just makes the very short point, so I wouldn't turn it up at this stage, but to make the point that just because it's the right is granted by statute doesn't make this right not civil and commercial, which would be a very obvious point, because of course the law of tort of almost all member states is set out in a code. Yes, I mean, on the further submissions, my lord, I mean, it's slightly disconcerting for my opponent to be invited to go away and dig away until he finds some authority to support his proposition. One might have hoped he might have brought it along and put it in the bundle. But anyway, there we are. So if your lordships feel it's necessary, I mean, it's...
I think the answer is that obviously you have both the opportunity, but if there is any, I think, more directly in point authority, you better supply it within a week. But at the moment, I'm surprised that there are not examples of cases in the Court of Justice which are closer to the present. But that may just be an erroneous surprise. Certainly don't.
It's one of those areas, my lord, where there are lots of cases, and in fact the rationale of the cases is not easy to discern. It's one of those areas, in fact, where there are possibly too many cases going references to the court, and so they're dealt with by different chambers.
Yes, they're all fact. All right. Well, we're not encouraging, I think, a large-scale exercise with lengthy submissions, and but something very brief. If you do find something that is really telling on either side.
Thank you, my lord. So very briefly, I think learned friend didn't really deal with Article 4.3. Perhaps just turn up the last point, Rome 2 in bundle 1. In his written case, he certainly prays in aid. So it's at page 396 in tab 7 of the first bundle.
4.2, did you say?
4.3.
Yes, 4. I was going to go to 4.3 first, because I can deal with that very quickly. So 4.3, this is in my learned friend's written case, says that, he says that the claim, this is his written case, paragraph 80, he argues that the claim is more closely connected with England. I mean, the first point I make on that is that the test in 4.3 is whether the tort is manifestly more closely connected with a country other than that indicated by the rules above. The second point I make is that the respondent argues, again in his written case, that there were no substantial connecting factors with any other country apart from England. And here the accident took place abroad, and this is the primary connecting factor. So that's Article 4.3, very quick. Under Article 4.2, which he did deal with briefly just at the end of his submissions, learned friend puts it that the person claimed to be liable under Article 4.2 is the MIB. I mean, the first point I make on that is that the correct construction is that the person claimed to be liable is the tortfeasor, because that's the person whose legal responsibility is in issue. And when we look, the only other place in the regulation where that term occurs is in Article 17. In assessing the conduct of the person claimed to be liable in Article 17, account shall be taken as a matter of fact, insofar as appropriate, of the rules of safety and conduct which were enforced at the place and time of the event giving rise to liability. The person claimed to be liable, I mean, obviously, there can be different forms of liability, but we draw attention to that. It's looking at the underlying liability, even if there are subsequent claims against other parties. The second point I'd make is that if you had a direct claim against an insurer, it's clearly not the habitual residence of the insurer which would count if you were to try to apply Article 4.2 to such a claim, to determine the law applicable to such a claim. Learned friend in his written case refers to the concept of vicarious liability and says, and cites a passage from Dicey. Just point out that vicarious liability as an employer, the employer bears the actual liability as the principal tortfeasor. He's not indemnifying someone else.
Well, Article 18 deals with direct actions against the insurer.
Well, indeed, Lord.
Yes.
So, I think that... I've come to the end. Lord, I think... let's have a quick last look through my notebook to see whether there's anything else I should have come across. But I think those are the main points, my Lord, unless your other lordships have particular points I'd like to raise.
Thank you very much indeed. Well, the court is grateful to counsel and those who prepared the case on both sides and will take time to consider its judgment.